What's going to happen is we're going to show videos that the presenters has kindly made summarizing the case law in America and Australia. The presenters are on Skype, so afterwards, if there's time, we will have Q&A and hopefully one can then ask questions to them as well. Okay, we're going to start with the first presentation by Scott.
Good afternoon, everyone. My name is Schoettes, and I'm the HIV Project Director at Lambda Legal. I'm thrilled to be joining you at the Lawyers for HIV and TB Justice training in Johannesburg, South Africa, via video today. I wish I could be there in person, and hopefully next time I will be able to be there in person. I was not able to join this time because I'll actually be presenting at the American Bar Association's HIV Law and Practice Conference. It happens once every 2 years here in the United States. And I just wanted to put an invite out there to folks who are English speakers and might be interested. We will be talking about HIV criminalization at that conference this year, as well as a host of other HIV-related legal issues that I think might be of interest to some of the lawyers at this training. So with that, I'll jump in. I'm here to talk about the American jurisprudence when it comes to HIV and TB criminalization, although my presentation will focus heavily on the HIV aspect of that, because that is where I have done a bunch of my work. I've been working in this space for about 10 years. I am a person who is living openly with HIV, and I've been advocating and working at Lambda Legal since 2007 on this and a host of other issues. We'll actually see as we move into the talk that I have been involved in a number of the cases that are actually a part of the compendium of cases that you have. And I'm going to talk to you about those cases, our involvement in them, my understanding of what transpired there, and then some of the takeaways that I think are important from those cases. So I wanted to just first acknowledge, I'm going to put my glasses on here, otherwise I won't be able to read my notes. I wanted to first acknowledge that we're in the United States, where these laws are controlled primarily at the state level. So there are 50 different states in the United States, which means that there are 50 different sets of laws that address this topic in a variety of ways. So that can be a bit of a challenge when trying to both work in the United States as well as trying to reform these laws here in the United States, because there's such a wide variety of how this is actually addressed here. I will say that there are prosecutions in the United States in states where there are indeed HIV-specific criminal laws that sometimes also include TB or other infectious diseases, but are oftentimes singled out for HIV is singled out for punishment under these laws. But there are also plenty of states where there are general criminal laws used either as well in conjunction with an HIV-specific law at different times, or general criminal laws are used when there is not an HIV-specific law on the books. So, and I'm sure you've talked about this, but things like assault with a deadly weapon, reckless endangerment, attempted murder, and various types of things like that have been used in the United States. So there's a challenge on a couple of different levels there. When I went to look at the compendium of cases that they had put together on the American front, I was pleased to see that I was familiar with almost all of them and had been involved in one way or another in 5 of those cases. So I'm going to talk a little bit about each of those cases that I was involved in and what I think it means for us as advocates. So the first one I wanted to talk about, and this is in your compendium, is State of Michigan v. Allen. I consider this a case that is sort of the low-hanging fruit in terms of fighting these kinds of convictions, at least here in the United States, because it involved a situation where HIV was not possible to transmit HIV. And so I feel like, and this was certainly true in terms of my career and my involvement at the beginning of my time at Lambda Legal, we really focused more on these cases where transmission was not possible, and we felt like we had a role to play in bringing to the court's attention that HIV was not transmissible in that context. Bringing information about HIV to the court, because I will say that our judges and also then our juries are woefully uninformed when it comes to HIV, its transmission, its treatment, the current prognosis for living with HIV, and that lack of information then plays out throughout whatever prosecution is taking place. So at Lambda, we work through sometimes an amicus brief, bringing to that court's attention the real information about HIV. And this case of of Michigan v. Allen was one of those instances. This was a man who had actually gotten into an altercation with another man. And during that altercation, there was an allegation that there was blood from the HIV positive person. And as the fighting went on, that some of that blood came into contact with the other individual. So it wasn't a case of sexual transmission, and this is an interesting point about this case. Michigan actually has an HIV-specific law that pertains to sexual contact. It's actually a horribly written law because it was written so broadly and actually involves the penetration, however slight, of any of a person's genitals into the body of another. And so it encompasses a bunch of situations that really pose no risk of transmission. In fact, someone in Michigan, a stripper, had been prosecuted for giving someone a lap dance and for allegedly having that person's nose inside of the stripper's vagina for some very short period of time, I would imagine. And so Michigan has this horrible law in the books when it comes to sexual contact. However, because prosecutors were dealing with a situation where there was no sexual contact, they had to go and rely upon the general criminal law to address this prosecution. So they decided in Michigan, and this was really quite shocking to all of us, to bring this charge under the bioterrorism law. And it was about transfer of a harmful biological substance. That was actually the allegation that was made in this case. And as I said, this law was written really to address bioterrorism. It had nothing to do with HIV, but the prosecutors reached out into the law to find something that they could use to prosecute and punish this person living with HIV more severely. So I really think the case shows the length to which prosecutors are willing to go in order to prosecute people living with HIV. And we submitted an amicus brief right off the bat to this court because we knew that this charge of bioterrorism was ridiculous and that the facts did not fit what the law was trying to do. And we submitted an amicus brief along with others explaining to the court just how HIV is and is not transmitted, that this was not a method on the blood of someone's fist during a fight, that was not the way HIV was going to be transmitted, and there was a good outcome in that case, and that the court found that that charge was not sustainable under the facts of that case. The next case I want to turn to is actually a similar situation in terms of what I described as that low-hanging fruit, situations where it's really not possible to transmit HIV. And this is the case of People of State of New York v. Plunkett. Again, this person was involved in a confrontation. This one that actually was between the person living with HIV and police officers. So in the process of being arrested, and this person, it was alleged, had some mental difficulties. So his mental health was not good, and it was alleged that during the time of his arrest that he had bit a police officer. And once they found out he was HIV positive, then they added this charge in New York that was assault in the first degree, which required that there be a deadly weapon or dangerous instrument used in the assaultive conduct. And Mr. Plunkett was convicted, and what the state had contended was that his teeth and his saliva were the dangerous instrument in this case. And so when we became involved, again, this was at Lambda Legal, and we wrote an amicus brief in this case as well. Although we were also much more intimately involved in this one, I worked pretty extensively with defense counsel on appeal. It ended up going to the New York High Court of New York State. And I mooted her before the case, and I was there for oral argument, sitting with her at the table, and had, so in addition to submitting our amicus brief, we had worked closely in helping her shape her argument before the court. And really what it was about was getting the court to recognize that a person's HIV could not be considered a dangerous instrument in these circumstances. That teeth, as a part of the person's body, as well as their saliva, was not, one, that it was not possible to transmit HIV in this way, that there have been no documented cases of transmission, as you all know, but also that that it did not make sense to classify this as a dangerous instrument that would be utilized. Court was great because indeed it went beyond saying the fact, holding that this wasn't a way in which HIV was transmitted, but went on to say that indeed the teeth and the saliva of a person living with HIV could not be considered a dangerous instrument under the definition of the law. In part because they said that the saliva of a person was a naturally occurring bodily fluid. In other words, there was no way for this person to have engaged in this particular assaultive conduct without HIV being, without his saliva being present. So it isn't as if he made a choice. And they held that indeed it could not be a dangerous instrument for that reason. I want to add to that I think one of the important things about this case is that it could be read much more broadly than applying only to saliva. I think if the right case came along, I would look to challenge whether, if they were trying to prosecute someone for sexual contact, I would challenge that prosecution under this precedent from the High Court of New York, saying that indeed semen or seminal fluid or vaginal secretions are a naturally occurring bodily fluid that the person is not bringing in order to engage in conduct that will hurt someone else, that would be considered a dangerous instrument under New York law. So I think that there's a broader application of that law that is, or that holding, that is important when it comes to the New York law. The next case I want to talk about is State of Minnesota v. Rick. This was an interesting case, and again, we were amicus in this case, along with a number of other organizations. Mr. Scott, I should say, oh no, his last name was Rick, was prosecuted under two different provisions in Minnesota. There was a provision of the law that applied, and it was specific to HIV, and it applied to, or actually, it involved other infectious diseases as well, but it applied to sexual contact and transmission of an infectious disease through sexual contact, but there was a separate provision that applied to things like donation of sperm or other bodily fluids or organs. And they prosecuted him under both of these provisions. The provision pertaining to sexual contact, however, had an affirmative defense that allowed a person to show that they had indeed disclosed their status, in which case they could not be convicted. And amazingly, I would say, Mr. Rick was able to convince a jury or create enough reasonable doubt in the jury's mind as to whether he had disclosed his status to his partner, that they did not convict under that count. However, the prosecutions proceeded under the other count, and because it was about donation of sperm and other bodily fluids or organs, it did not contain an affirmative defense for disclosure. So Mr. Rick was prosecuted and was convicted under that other statute. So really what this case became about was whether or not that provision could be applied in the sexual context. The operative word there was transfer. It had to involve the transfer of semen, and the state was alleging that the sexual act involved the transfer of semen. But it was very clear that what it was written for was to address donation of semen. And eventually, this again worked its way all the way up to the High Court of Minnesota. The defendant prevailed in convincing the court that indeed the only provision that could be applied to his conduct was the provision applying to sexual contact. I want to say that it was, as I said before, I think it was pretty remarkable that he was able to convince a jury that he had disclosed, because I would say that in most of these prosecutions that occur, the person living with HIV is usually at a tremendous disadvantage in terms of convincing a court that they are the credible one, and that the person who was not living with HIV prior to the contact was, if it was transferred, if there was transmission, that person is lying. I would say that in most cases, a judge is going to come in with a bias against the individual living with HIV for a whole host of reasons that I think we all understand. And so it's quite remarkable that in this case, Mr. Rick prevailed in that defense. And so I think it's important to note that it can happen. And I think you just need good enough facts and good enough evidence to, in the United States, sow reasonable doubt as to whether that in fact occurred. And this case once again shows just the lengths to which prosecutors are willing to go. Even though they knew that, I think it was clear that the statute they were trying to use should not be applied to this conduct at issue, they were willing to use whatever was at their disposal because people get so hyped up about these kinds of prosecutions and what they perceive to be unlawful conduct. The next case I want to tell you about is one that was just resolved relatively recently here in the United States, and it isn't completely resolved yet, but this is the case of State of Missouri v. Michael Johnson. So, first of all, I just want to say that the law in the state of Missouri here in the United States is an awful one. There are varying degrees of how bad these laws are, and Missouri has one of the worst. It is a 15-year sentence, up to 15 years, for exposure without transmission, and then 30 years for exposure with transmission. So it's a very severe penalty. It really is a strict liability crime. It does not take into account intent or whether there was any substantial risk of transmission. It's really about if you're a person living with HIV and you've had sex and you did not disclose, or you cannot prove you disclosed, you're going to be convicted under this law. And it's pretty horrible. The case also had, I think, some pretty horrible facts. So Michael Johnson was a young wrestler attending school in Missouri. He was a black man. It's unclear exactly when he discovered he was HIV positive, but he was not engaged in treatment at the time. And there were 6 different people who he had had sex with, most of them white, young men here in the United States, and 6 of them were willing to come forward and say that he had sexual contact with them without first disclosing his HIV status. So the facts were pretty awful in terms of trying to go into a court and win in a case like this. It's also the case that Michael was offered during his defense pre-trial, and in this case we were actually involved. I was involved with the public defender, working with her. We were not directly involved. We were not of counsel. At one point we offered to be of counsel in order to try and get the court to allow us to bring in some of the scientific evidence around HIV and its transmission to show that Michael had not transmitted. There was one person out of the 6 who alleged that Michael had actually transmitted HIV to him. He was now HIV positive. And so we wanted to bring in that evidence, but we didn't get to do that. However, I did get to work with the public defender and try to inform her process in defending this case. I will say that those things did not all go as well as I would have liked, and I was somewhat frustrated because I wasn't defending Michael, and I wasn't sure he was getting all of the attention that his case really required. Public defenders in the United States are very overworked, and it did not. It was not easy for this person to defend this case as well as the dozens of other cases that she was defending at the same time. So he was offered a plea during that prior to trial, and she had worked it into the position where I think she got a reasonable plea offer from the defense. It was for 10 years, and considering that he was facing up to 90 years based on the allegations before the court, I think it was not a bad deal, especially given that after serving 1/3 of that time, he would have been eligible for parole. The trial in that case in Missouri, which is a southern state here in the United States, I will say was, I think, a mess. It was really permeated by racism and homophobia. I would say just sex phobia in general, and some of the puritanical attitudes that continue to exist in the United States around sex. There were pictures shown. Some of the sexual encounters had been videotaped, and those were shown to jury members, I believe, to inflame jury members around the sexual contact between two men. And then finally, it was clear that they were going to stoke fears about HIV as much as possible, and talked about the risk that they were that he was putting everyone in the community, and really in many ways put the jurors in the shoes of those who would be put at risk by Michael Johnson's conduct, which you're not supposed to do in the United States. And it was a horribly run trial, and it was a sad, I would think, miscarriage of justice. Now, all of that said, I think this was going to be an incredibly hard case to win, in part because he had 6 people willing to testify against him, and he decided to take the stand himself, which you don't have to do, and to dispute the accounts of all of these witnesses. And I just think it was really difficult to convince the court that indeed he had disclosed, even though there were 5 people saying he had not, 5 or 6. So he ended up being sentenced to a total of 60 years, with those sentences, some of those sentences running concurrently, so that his sentence was going to be for 30 years in the state prison. And I would say that he was very fortunate in that on appeal, it was discovered that the prosecutor had held back some evidence until right before the eve of trial. This was a violation of the court's rules of evidence, and indeed the conviction was reversed on those grounds, which gave him a second bite of the apple. And when they went back down, potentially to retry the case, he was once again offered that plea deal. And I think he's fortunate that he was offered the same plea deal, and he took that plea deal and is awaiting now to be considered for parole. He ended up serving, now he's serving longer than he maybe necessarily would have had to if he had taken the deal originally, but it will be much closer to what that original deal would have been than it will be to the maximum that he could have ended up serving of 30 years. So finally, I want to talk about, I think the lesson out of that last case is that sometimes you take the deal. A bunch of these cases are really just not winnable, or they're not likely to be won. And so I think it's really important to be able to assess the case, really have a conversation with your client, even though they may maintain their innocence and feel it is anathema to take a deal in this situation. I think sometimes it's important to tell them what the facts are in terms of the law, and how it is likely to unfold, because I think he could have put himself in a much better position had he been convinced of that at the beginning. So finally, I want to talk about Rhodes v. Iowa, and I'm afraid I might be running a little over time here. This is actually the case in which we were most involved here at Lambda Legal, and of which I'm really quite proud. So Rhodes involved a young man in Iowa who had a one-time sexual encounter with someone he met online. They got together, had a few drinks, and ended up having a sexual activity between them. HIV status never came up. They engaged in oral sex without a condom, anal sex with a condom. However, Nick had an undetectable viral load. And as we know now, it is clear that if you have an undetectable viral load, it's impossible to transmit HIV. But none of that mattered. When the person who he had this encounter with found out that Nick was HIV positive, he really kind of freaked out. He went to try and get treatment at a hospital with post-exposure prophylaxis. They turned him down, I think, because they realized he was not really at any risk based on the activities in which they had engaged. But that did not deter him. He went to another hospital, this time a religiously affiliated hospital, and they not only gave him his post-exposure prophylaxis, they also told him that if Nick had not disclosed his status, that was illegal in Iowa, and that he could have Nick prosecuted. And he did. And the law in Iowa, like the law in Missouri, is really quite draconian and horrible. It can result, and often does, in a 25-year sentence for someone living with HIV who has sex without disclosure or without being able to prove disclosure. It is really a strict liability crime again. It requires no intent to transmit. It doesn't require actual transmission. Doesn't require conduct that poses a substantial risk of transmission. And Nick, I would say, was given some not great advice of counsel in this case because I think there was a way of reading the statute that we later took up, and I'll explain that. But he decided to plead guilty, in part because he thought that he would get leniency from a judge who would understand. And I want to pause here to say I think that a lot of the defendants in these cases have not had any contact with the criminal justice system before. They are not used to how the criminal justice system works. They're not used to being interrogated by police. And so I do think it's important for practitioners to keep that in mind and as soon as possible to get to your client so that you can get them to stop talking to the police, because the police will convince that person that they are their friend, that they're going to help them out, that the judge will go lenient, that they will go lenient, that the prosecutor will be lenient if they just cooperate, and they end up incriminating themselves in ways that are not helpful. In this case, Nick thought that he would get leniency from the judge, and so he pled guilty, and he was sentenced to 25 years in prison, even though there was no transmission, no real chance of transmission of HIV in this case. So we eventually Nick served about a year and a half of that before his sentence was reconsidered after a campaign by advocates, and he indeed got his sentence suspended and then was put on 5 years of probation. However, he was still a convicted felon with all the consequences of that, and he was considered a sex offender here in the United States, which required an entire host of things that he had to comply with as a result of that, including not being able to spend time with his young niece and nephew, even though the conduct in which he engaged involved consensual conduct with another adult. The issues that we then took up, so Nick, we appealed in a post-conviction relief proceeding on the civil side to get his conviction overturned. And we joined really at the appellate when that had already gone through a trial determination, and he lost a trial. And the reason we took the case was we believed that the way the statute was written, that indeed it said that the intimate contact which was prescribed in that case was anything that could result in the transmission of HIV. And we thought that there was a way to argue that the contact in which Nick had engaged was not something that reasonably could result in the transmission of HIV. There were some problems, however, with this any risk standard versus a reasonable possibility. So our interpretation was that there had to be some reasonable possibility of transmission. And really, the way the statute was written, it was any possibility because it said could transmit. And indeed, the court in Iowa had previously held that oral sex was sufficient. It had decided that ejaculation was not necessary. It had examined the statute in the past and allowed convictions that involved oral sex, that did not involve ejaculation. And the court had previously said that the state prosecutors could rely on generally accepted principles about how HIV was and was not transmitted. And so previous convictions had basically been reliant upon or built upon this idea that, yes, you can transmit HIV anytime there is sexual contact. So we needed to convince the court not only to interpret its statute in a way that it had not in the past, but also to really go back and change the way it was thinking about this statute and how it should be applied, and reverse itself on some of these previous cases. Amazingly, so we lost at the appellate level, and amazingly, we got to take the case to the Iowa Supreme Court, and we were able to convince the Iowa Supreme Court that the facts on the ground had changed, that the science around HIV had taught us about where the real transmission risks were, and indeed that a person living with HIV had very little to no chance of transmitting HIV to another person. So that state Supreme Court really reread and massaged its previous holdings around this statute and interpreted it now so that could result in HIV really meant that there was a reasonable possibility of HIV transmission from the contact involved. The court held that that had not been shown in Nick's case, and Nick's case was remanded. The conviction was vacated, and his case was remanded for further adjudication. The good news here is that once it came back down and the state had realized what it was going to have to show, it realized it wasn't going to be able to show it, and they decided not to prosecute Nick. So not only was he no longer a sex offender, but he was no longer a convicted felon. There is a happy ending to that story, no pun intended, and I think it is a real victory upon which we hope to continue to build here in the United States. The other thing, and this will be my closing, that I want to tell you about the law or what happened in Iowa, is that we were able at the same time to engage in legislative reform, and we got Iowa's law changed so that it no longer reads in the same way. And we've been involved, Lambda Legal has, in now a number of jurisdictions where we are attempting to do the same thing. And maybe I will come back next time to talk about some of those efforts and the success that we are having in some places in the United States in reforming or getting rid of these laws. So with that, I'll close. I thank you for your time and attention. And if everything goes well, I will be doing a Q&A with you at the end of this session. Thanks.
Thank you, Scott.